I did not sleep well anymore. Not since the cameras went in. I poured my coffee at 5:45 on a Tuesday morning and opened the security app on my phone. 8 camera feeds. 8 angles across 6 acres of Virginia farmland my grandfather broke ground on in 1961. I scrolled through the overnight motion alerts like another man might scroll through emails. Routine, expected, unremarkable. Then I stopped. Timestamp. 11:47 p.m. Camera 4. East field, 40 yards from my vegetable beds. 3 figures. Flashlights cutting low across the ground. One carrying a clipboard. One unrolling a measuring tape between my fence posts. I recognized the one in front immediately. Linda Marsh. President. Standing inside my property line at midnight like she already owned it. 6 times in 4 months. I had all of it recorded. They thought the dark would hide them. They forgot about the cameras. And what those cameras caught was about to cost them everything. My name is Nathan Cole. I am 47 years old, and I have lived on this land my entire life. First as a boy following my grandfather between the vegetable rows in the early morning. Then as a teenager learning to read soil and weather and the particular way this valley holds rain. Then as an adult who turned down steadier work in the city because I could not imagine waking up anywhere else. I run a small organic operation: vegetables, chickens, 2 goats. Nothing glamorous. Nothing that required explaining to anyone. My grandfather built the farmhouse by hand in the summer of 1961. Every beam placed by his hands. It is still standing. Still solid. I inherited this land 11 years ago when he passed. I paid my HOA dues on time. Maintained my property without complaint. Never filed a grievance against anyone in 20 years. I had simply wanted to be left alone to farm my grandfather's land. That turned out to be too much to ask. I had seen Linda Marsh's pearl-white SUV in my rearview mirror more times than I could count. She had been HOA president for 5 years. Before that she had been a real estate agent, residential properties, new developments. The kind of work that trained a person to look at land and see not what was there but what could replace it. She drove that SUV like a declaration, parked it at angles that suggested authority. She had a way of making routine neighborhood business sound like policy directives from a higher level of government, and most residents had simply gotten used to deferring to her because the alternative was a conversation nobody wanted to have. I had never had a problem with her. Not directly. I paid my dues, kept my fences maintained, and stayed out of HOA politics the way my grandfather had stayed out of things that were not his business. He had a saying about that. Mind your land and your land will mind you. I had lived by it for 20 years. The morning she knocked on my door, I was coming in from the chicken coop. Still had feed dust on my jacket. She was standing on my porch in a blazer, holding a clipboard, with the particular expression of someone who had rehearsed this visit. She told me she was there on official HOA business. I told her to come in. She declined, which I noted. People who decline to come inside have already decided the conversation is going to be adversarial. She handed me a formal violation notice. 3 items listed. First, my chicken coop violated HOA aesthetic guidelines regarding visible outbuildings. Second, my vegetable beds along the south fence were classified as unsightly under residential appearance standards. Third, the hand-painted wooden sign at my farm entrance, Cole Family Farm, established 1961, was unauthorized signage under HOA exterior display rules. I read all 3 items twice. Then I looked up at her. I told her I would be right back. I went inside to the filing cabinet my grandfather had built into the wall of the back hallway, solid oak, 4 drawers, the kind of furniture built to last a century. I knew exactly where the documents were. I had read them when I inherited the property, and I had kept them organized ever since. I pulled 2 items, my original property deed, and the Pinecrest Valley HOA charter as filed with the county in 1987. I brought them to the porch and opened the charter to Section 11, Paragraph 3. The Agricultural Exemption Clause. Properties operating as active agricultural enterprises, prior to the establishment of the HOA, retained the right to continue agricultural use exempt from standard residential appearance guidelines, provided the operation remained active and the property taxes were current. My grandfather's farm had been operating since 1961. The HOA had been established in 1987, 26 years of farming before a single bylaw existed. I showed her the paragraph. She looked at it with the expression of someone who had expected this exact document and had already prepared her response. She told me that a recent bylaw update had addressed legacy exemption clauses, and that the updated guidelines now applied uniformly across all properties in the development regardless of prior use history. I asked her to show me the bylaw update. She told me it would be mailed to me within the week. I told her I would wait for it before taking any further action on the violation notices. She smiled the smile of someone filing something away internally, thanked me for my time, and walked back to her SUV. I stood on my porch and watched her go. And I noticed something that stayed with me for the rest of that day. She did not leave immediately. She sat in the driver's seat with the engine off for a long moment, and I watched her eyes move slowly across my property, not casually, not absently, but with the deliberate attention of someone taking inventory. She was looking at my outbuildings, my vegetable rows, the spacing of my fence lines, the layout of the access paths between the growing beds. She was studying the geometry of my land. Then she started the engine and pulled away. That evening, I pulled up my single driveway camera. The footage showed her SUV sitting at the edge of my property for 11 minutes after she left my porch. Engine running. Facing my fields. 11 minutes. The bylaw update she promised never arrived. Not that week. Not the week after. Not ever. But I had already made my decision. The next morning, I called a security company. I told them I needed cameras on every acre. Motion activated. Cloud stored. Every angle covered. If Linda Marsh wanted to study my land, I was going to make sure I had a record of every time she tried. The installation took 2 days. 8 cameras. 4 covering the field perimeter, 2 on the outbuildings, 1 on the front entrance, 1 on the east field where the vegetable beds ran along the back fence line. Motion activated. Night vision capable. Footage uploaded automatically to cloud storage every 30 minutes. The technician who installed them asked me twice if I was sure I needed this level of coverage for a residential property. I told him it was not a residential property. It was a farm. He nodded like that explained everything, which it did. I tested every angle before he left. Walked the perimeter myself, checking the app on my phone as I went, making sure there was not a single entry point that was not covered. My grandfather had built stone markers at each corner of the property in 1962, rough field stone, knee-high, weathered 60 years, but still exactly where he placed them. I used them as reference points. If anyone crossed inside those markers, I would have it on camera. I went to bed that first night and slept better than I had in weeks. The first trespass came 9 days later. I was in the kitchen at 6 in the morning when the motion alert came through on my phone. Camera 4. Eastfield. Timestamp from the previous night, 11:14 p.m. I set down my coffee and watched the footage. 2 figures. Moving along the interior fence line, staying low, flashlights pointed at the ground rather than ahead of them. The taller one was carrying something. I could not make it out in the first pass, so I expanded the footage and watched again. A measuring tape. Extended between them as they walked the fence line, one holding each end, pausing every few feet. I recognized Linda immediately. The second figure took me a moment longer. Gary Purcell, her closest board ally. A man I had exchanged perhaps 40 words with in 20 years of living in the same neighborhood. They were on my property. Inside my grandfather's stone markers. At 11 of the clock at night. Measuring my fence line. I watched the footage 4 times. Then I called Rachel Kim. Rachel Kim had been practicing property and HOA law in Virginia for 14 years. A colleague had recommended her the previous week when I mentioned I might need legal counsel. I had been considering it since Linda's visit, and the footage made the decision for me. We met in her office that afternoon. I brought my phone, my property deed, the HOA charter, and the violation notices. She watched the footage without speaking. When it finished, she watched it again. Then she looked up at me and said something I had not expected. She said the trespass was a criminal matter entirely separate from the HOA property dispute. She said we were going to handle both, but that the footage I had just shown her was not civil evidence. It was potential grounds for criminal charges. She told me to keep recording, keep storing everything off-site, and not to confront Linda or any board member directly under any circumstances. I asked her why not. She said because right now Linda thought she was managing a resistant property owner. She did not yet know she was being documented. That gap between what Linda believed and what was actually happening was the most valuable thing I had. Rachel did not want me to close it prematurely. I understood immediately. It was the same principle my grandfather applied to problem animals on the farm. You do not chase them off the first time you see them. You find out where they are going first. I began my own investigation in parallel. I spent 3 evenings talking to neighbors, not about Linda specifically, not initially, but about the neighborhood generally. How things had changed. what they had noticed. Older residents were more forthcoming than newer ones. A retired couple 3 houses down, the Hendersons, told me that Linda had mentioned my property at 2 separate neighborhood gatherings over the past year. Not in a confrontational way, casually, the way you mention something you have been thinking about for a while. She had described the farm as underutilized, had wondered aloud, more than once, whether the land might serve the community better in a different configuration. Different configuration. I wrote that phrase down. Another neighbor, a woman named Carol Briggs, who had lived in the development for 16 years, told me that approximately 8 months ago she had overheard Linda on her phone in the clubhouse parking lot. She had not been trying to listen. She had simply been walking past. She heard Linda say, clearly and without apparent concern about being overheard, "The agricultural exemption is the only obstacle, and that can be addressed through the county." I asked Carol if she would be willing to write that down. She said she would think about it. The violation notices began arriving weekly. The first cited noise levels from my chickens exceeding residential sound guidelines. I measured the sound levels myself with a decibel meter and documented the readings, well within any reasonable standard. The second cited odor from my compost operation as a community nuisance. The third cited the height of my sunflowers along the south fence as a visibility obstruction. The fourth cited my water collection barrels as unauthorized exterior structures. Each notice was signed by Linda in her capacity as board president. Each referenced bylaw provisions I could not locate in the county registered charter. Each arrived on official HOA letterhead with a fine schedule attached. Rachel told me to contest every single one in writing and comply with nothing. She said the pattern was deliberate. Linda was constructing a paper trail designed to characterize me as a chronically non-compliant property owner. If she could establish that pattern in writing, it would support her eventual argument to the county that my agricultural exemption should be reviewed and potentially revoked. Revocation of the exemption was the mechanism. Without it, my land was protected. With it, everything changed. I filed written responses to every notice through Rachel's office. Polite, documented, legally precise. I complied with nothing. On a Sunday afternoon, I was reorganizing the back hallway storage when I found my grandfather's original land survey. It was in a cardboard tube behind the filing cabinet, the kind of tube architects use, slightly flattened on one side from years of storage. Inside was a hand-drawn survey map dated April 1961, the property boundaries, the building placement, the access paths, all rendered in my grandfather's careful drafting hand. And in the margins, in his small, precise handwriting, were notes. Measurements he had rechecked, boundary markers he had confirmed with the county surveyor. A note that read, in his particular shorthand, "Corners set in stone, permanent." He had meant the physical markers. The fieldstone corners he placed that year, and that were still standing 60 years later. But sitting on the floor of that hallway with the survey unrolled across my knees, I thought he might as well have been describing something larger. This land had been surveyed, documented, and legally established 60 years before Linda Marsh decided it suited her plans. The corners were set. They were not moving. I rolled the survey carefully, returned it to its tube, and put it somewhere I could find it quickly when I needed it. The second trespass came 4 days later. Camera 4 again, this time at 9:47 p.m. Linda alone, moving along the Eastfield perimeter with a camera, her own camera, a proper one, not a phone. She stopped at 3 different points along my vegetable beds and photographed my outbuildings from inside my property line. She was there for 6 minutes and 20 seconds. I watched the footage from my kitchen table. I did not go outside. I did not call her. I did not move. I just watched and saved the file and waited. The emergency HOA meeting notice arrived on a Thursday evening. A flyer under my door, same as everyone else's. Meeting scheduled for Saturday morning at 10. 36 hours notice. The stated agenda read: Community health, safety, and property standards. Urgent discussion. I read it standing in my doorway in the evening light and understood immediately that I was the agenda. The language was careful enough to avoid naming me directly. But there was only one property in Pinecrest Valley currently under active violation review. Everyone would know who the meeting was about. I called Rachel. She told me to attend, say nothing unless directly addressed, and observe everything. She said the meeting itself was potentially useful. Whatever Linda presented publicly would become part of the documented record. Let her talk, Rachel said. People who are confident they are winning say more than they intend to. I wore my cleanest work jacket and arrived 5 minutes early. The clubhouse held about 40 people. I had not seen that many residents in one room since the development's 10th anniversary block party 7 years ago. Linda had done her work. She had personally called or visited most of the attendees in the preceding 36 hours, which I learned afterward from 3 separate neighbors who mentioned it without realizing the significance. She opened with a slideshow. It was professional. Genuinely professional, formatted, sourced, organized with the kind of precision that told me she had prepared it well before the violation notices started arriving. This was not a presentation assembled in response to a problem. This was a presentation that had been waiting for the right moment to be used. The first section covered noise complaints. A bar graph showing reported disturbances in the development over the past 18 months, with a sharp increase in the most recent quarter. No names on the graph, no addresses. Just numbers climbing toward the right side of the screen, while Linda described the impact on residents' quality of life in her warmest, most concerned voice. The second section covered odor complaints. Similar format. Similar language. A photograph of a compost operation, not mine specifically, just a generic image of compost barrels accompanied by statistics about residential odor standards. The third section was titled Structural and Aesthetic Concerns. This one had photographs. My photographs. My chicken coop, my vegetable beds, my water collection barrels, my sunflowers along the south fence. The images were taken from inside my property line. I recognized the angles immediately. They were the angles from Linda's second trespass. The photograph she had taken on her own camera at 9:47 on a Tuesday evening while standing on my land without my permission. I sat very still and said nothing. The report came next. Linda distributed printed copies to everyone in the room. 12 pages, spiral-bound, the Pinecrest Valley HOA logo on the cover. It was titled Community Concerns Report, Cole Family Farm Property. My name. In the title. Distributed to 40 of my neighbors on a Saturday morning. The report cited noise levels, odor complaints, structural irregularities, and what Linda described as ongoing non-compliance with community standards. It referenced 9 resident signatures as evidence of community-wide concern. It concluded with a formal recommendation that the county be petitioned to review the agricultural exemption status of my property on the grounds that the operation had become incompatible with residential community standards. 9 signatures. I counted them on the back page. 9 of my neighbors, apparently, had formally agreed that my grandfather's farm was a problem that needed to be solved at the county level. I took my copy, folded it carefully, and put it in my jacket pocket. I went door to door the following week. All 9 residents whose names appeared on that document. I did not go in groups. I went alone, one at a time, in the evenings when people were home. I introduced myself simply, my name, my address, the farm they had driven past for however many years they had lived in the development. I told them their name had appeared on an official HOA document recommending the county review my agricultural exemption. I asked them if they had knowingly signed such a document. The responses were variations of the same conversation. 3 of them said they had signed a general community concerns petition that Linda had presented as a routine feedback form about neighborhood quality of life. They had not been told it would be attached to a formal recommendation targeting a specific property. 2 said they had signed something at Linda's door without reading it carefully because she had presented it as standard HOA business. 1 said she had signed because Linda had told her it was simply a record of attendance at a community discussion, not a formal complaint document. 1 said he had asked Linda what the petition was for, and she had told him it was about general noise standards in the development. Not one of them had knowingly signed a document recommending the revocation of my grandfather's agricultural exemption. I thanked each of them and went home and called Rachel. The developer letter arrived on a Wednesday. Plain envelope. Professional letterhead. Greenfield Properties, headquartered in Richmond. The letter expressed interest in acquiring my property for potential development and invited me to contact their acquisitions department to discuss terms. It was signed by someone with the title Senior Land Acquisitions Manager. I had not listed my property for sale. I had not contacted any developer. I had not spoken to anyone about selling. I had not, at any point in my 47 years of living on this land, considered selling it. I called Rachel immediately. She told me to forward the letter and say nothing to Greenfield. Then she made a call of her own. It took her 2 days to find the connection, but she found it. Linda's former real estate brokerage, the firm she had worked at for 11 years before transitioning into HOA management, maintained an active referral relationship with Greenfield Properties. Referrals that generated commission payments. Commission payments that created a direct financial incentive for Linda to facilitate land acquisitions on Greenfield's behalf. I sat with that information for a long time. The third trespass came on a Friday night. Camera 4 again, but this time 3 figures instead of 2. Linda, Gary Purcell, and someone I did not recognize. The unknown figure moved differently from the other 2, more purposeful, more technical. He stopped at 4 separate points in my east field, crouched down each time, and appeared to be collecting something from the soil. Small containers. The kind a field assessor might use for soil samples. I watched the footage 3 times. Then I sent it to Rachel with a single message. There are 3 of them this time, and one of them is not HOA. Rachel's response came within the hour. Do not touch anything in that field. I need to find out who the third person is. 2 days later, she called me back. Her voice was different, not alarmed, but deliberate in the way it gets when she is handling something carefully. The third figure was a land assessor, contracted by Greenfield Properties. On my land without my knowledge or consent, collecting soil data for a development feasibility assessment on property that was not for sale and had never been offered to them. I stood in my kitchen holding my phone and looked out the window at my east field, my grandfather's field, where he had turned the first soil in the spring of 1961, where his stone corner markers were still standing after 60 years. They had sent someone onto my land to assess it for development. Rachel had already called the sheriff's office before she called me. Rachel got the subpoenaed emails on a Monday morning. She called me at noon and asked me to come to her office that afternoon. Her voice had the particular quality it got when she had found something significant and was being careful about how she delivered it. I drove in from the farm still in my work clothes, soil on my boots, and sat across from her at the conference table where she had laid out a series of printed email chains in chronological order. She told me to read them in sequence. Then she sat back and let me read. The earliest email in the chain was dated 22 months ago. Linda had written it to a contact at Greenfield Properties, whose email signature identified him as Director of Land Acquisitions. The subject line read, "Potential Opportunity, Pinecrest Valley." The body of the email was 4 paragraphs. In the second paragraph, Linda described my property. 6 acres, active agricultural use, legacy exemption status. She described the exemption as the primary obstacle to acquisition and wrote, in her own words, that she believed the exemption was challengeable through county petition given the property's location within a residential development and ongoing community friction with the agricultural operation. There was no ongoing community friction 22 months ago. I had not received a single violation notice. Linda had not yet knocked on my door. The conflict she was describing to Greenfield as justification for exemption challenge did not exist yet. She was describing a situation she intended to create. I read that paragraph 3 times. Then I set the page down and looked at Rachel. She said, "Keep reading." The chain continued over 14 months. 6 emails from Linda to the Greenfield contact, 2 responses from him. The tone throughout was businesslike, familiar, the correspondence of people who had worked together before and expected to work together again. Linda provided updates on her progress. She described the violation notice campaign as proceeding on schedule. She referenced the community complaint document as nearly ready. In one email, dated 9 months ago, she wrote that she expected the county exemption review petition to be filed within 60 days, and that acquisition discussions could begin in earnest following a favorable county determination. Acquisition discussions on my land, while she was filing violation notices against my chicken coop. The final email in the chain was dated 4 months ago, 2 months before I installed my cameras. Linda wrote that progress had been slower than anticipated due to the property owner's resistance and legal involvement, but that she remained confident the exemption challenge would succeed, and that the timeline for acquisition remained viable. I was a timeline. My grandfather's farm was a viable acquisition. I pushed the pages back across the table toward Rachel and sat quietly for a moment. Then I asked her what the share purchase record showed. She slid a separate document across the table. Greenfield Properties was privately held, but had an investor registry maintained for internal purposes. Rachel had obtained it through the discovery process. Linda Marsh had purchased a minority share position in Greenfield Properties 18 months ago, 2 months after her first email to their acquisitions director, 4 months before she knocked on my door with the violation notices. She had bought into the company she was delivering my land to. Every violation notice she filed, every complaint document she circulated, every meeting she called, every trespass she conducted on my property at night. All of it had been performed by someone with a direct financial stake in the outcome. She was not an overzealous HOA president with a vision for community improvement. She was an investor protecting her position. I thought about my grandfather, about the kind of person who would look at 60 years of someone's family history in the soil and see a line item in an acquisitions portfolio. I did not say anything for a while. Rachel let the silence sit. Then I asked her about the land use notation. She had pulled the full title search on my property as standard procedure 2 weeks earlier. Buried in the filing history, recorded with the county 14 months ago, was a community land use interest notation filed by the Pinecrest Valley HOA. Rachel explained what it meant in plain language. It was a procedural claim not yet legally binding, but designed to establish a formal record of HOA interest in the property. If combined with a successful exemption revocation, it would have given the HOA legal standing to assert community use rights over my land. If left unchallenged for 3 years from the filing date, it would have strengthened significantly in any subsequent legal proceeding. Linda had filed it 14 months ago. I had installed my cameras 10 months later. I had caught the trespasses 4 months after that. If I had stayed uninvolved for another 2 years, if I had continued minding my land and assuming good faith from my neighbors the way my grandfather had taught me, the notation would have matured. The exemption would have been challenged. The acquisition would have proceeded. I had come within 14 months of losing my grandfather's farm to a filing I did not know existed. I went back to the 5 misled residents myself. Rachel had their contact information from the preliminary legal filings, and I called each one personally rather than having her office reach out. I thought they deserved to hear from me directly. I explained what the document they had signed had actually been used for. I explained the email chain, the developer connection, the financial stake. I did not dramatize it. I laid it out the way my grandfather would have, in sequence, without embellishment, letting the facts carry their own weight. All 5 agreed to provide formal statements. 2 of them were angry in the particular way that comes from realizing you were used by someone you trusted. One was quiet for a long time on the phone before she said yes. One said she had suspected something was wrong when she saw her name on the printed report at the HOA meeting, and had been trying to decide what to do about it ever since. When an older man named Bill Travers, who had lived in the development for 19 years, said simply, "I should have read it before I signed it. Tell me where to go, and I will say what I know." I thanked each of them. These were my neighbors. They had made a mistake under pressure from someone they had been conditioned to trust. That was Linda's doing, not theirs. I laid all 6 trespass recordings out in sequence on my laptop that evening. 6 nights. 6 separate entries onto my property without consent. Linda alone. Linda with Gary Purcell. Linda with the Greenfield land assessor. Timestamps, camera angles, figures clearly identifiable. The earliest dated to 9 days after my cameras went in. The most recent to 3 weeks before Rachel filed the first legal motion. Rachel watched all 6 recordings at the conference table without speaking. When the last one finished, she sat back in her chair and looked at me across the table. Then she picked up her phone and called the county sheriff's office. I sat back in my own chair and looked out the window at the parking lot below, and past it at the tree line, and thought about my grandfather standing at the edge of his east field in the spring of 1961 with a survey map in his hand and stone markers at the corners and 60 years of farming ahead of him. He built something worth protecting. I was protecting it. I prepared for the meeting the way I prepared for difficult seasons on the farm. Methodically, without rushing. Knowing that what I brought into the room would determine what I walked out with. Rachel had sent the formal meeting request 10 days prior, a single page citing my rights under Section 4 of the original Pinecrest Valley HOA charter. Linda's attorney had responded with 2 procedural objections. Rachel dismantled both in a reply filed the same afternoon. The meeting was legally required. The date was set. Thursday evening, 7 of the clock. Pinecrest Valley Clubhouse. I spent the 3 evenings before organizing my evidence into a sequence that any neighbor, not a lawyer, not a judge, just a person who lived on this street, could follow without difficulty. The emails, the timeline, the share purchase records, the land use notation, the trespass footage. Each piece connected to the next the way fence posts connect individual structures that only make sense when you see the line they form together. I did not prepare a slideshow. Linda used slideshows. I was going to stand in front of my neighbors and talk to them like a man who had nothing to hide and everything to explain. I arrived 20 minutes early. The clubhouse was already filling. By 7 of the clock, there were 41 residents in the room, the highest attendance at any Pinecrest Valley meeting I could remember. People were standing along the back wall. A woman I did not recognize was sitting near the front with a small notebook open on her knee. I noted her but did not approach. Linda was already at the front when I arrived, setting up her projector with the efficiency of someone who had done this many times. She was wearing a blazer I had not seen before, dark navy, more formal than her usual. Her board members were seated in a row to her left. Gary Purcell was among them, but he was sitting slightly back from the others, and he had arranged his face into an expression of careful neutrality, rather than his usual posture of visible support. I took a seat in the third row. Rachel sat beside me. Linda opened precisely at 7. She welcomed everyone, thanked them for coming, expressed her deep appreciation for the community's engagement with important neighborhood matters. Her voice was warm and unhurried. She had the composed confidence of someone who believed she controlled the room. She spoke for 15 minutes before yielding the floor to me. Her presentation covered familiar ground: the violation notices, the community concerns report, the petition for county exemption review. She had added new material: a section on residential property value impacts from adjacent agricultural operations, sourced from a real estate industry report, a section on community survey results showing resident support for the exemption review, a timeline of the HOA's engagement with my property presented as a patient, procedurally careful effort to address legitimate community concerns. She was good. I had always acknowledged that privately. She was genuinely good at taking a sequence of calculated actions and presenting them as reluctant responses to circumstances beyond her control. If I had been a stranger watching from outside, I might have found her convincing. But I had read her emails. I knew what she had written before any of this began. She concluded by expressing her hope that the community could engage constructively with the exemption review process, and her confidence that the outcome would benefit everyone in Pinecrest Valley. Then she gave me the floor. I stood up and turned slightly so I was addressing both Linda and the room behind me. I did not use the projector. I held a single folder of documents and spoke from memory, consulting the pages only when I was giving specific dates or figures. I had rehearsed the sequence enough times that it felt natural, not performed, just known. I started with the timeline. I told them when Linda had first contacted Greenfield Properties, 22 months ago. Before any violation notice. Before any community complaint. Before she had ever knocked on my door. I told them what she had written in that email, that my agricultural exemption was the primary obstacle to acquisition, and that she believed it was challengeable. I told them she had written those words when, by the HOA's own records, there was no documented community concern about my property whatsoever. The room was quiet in the particular way rooms go quiet when people are recalibrating what they thought they knew. I moved to the share purchase records. I told them Linda had purchased a minority share position in Greenfield Properties 18 months ago, 2 months after her first email to their acquisitions director. I told them what that meant. Every action she had taken against my property since then, every violation notice, every complaint document, every meeting had been taken by someone with a direct financial stake in the outcome of those actions. A murmur moved through the room. Linda made a note on her legal pad without looking up. I moved to the trespass footage. I had a laptop connected to the clubhouse projector. Rachel had arranged it quietly while Linda was presenting. I opened the first recording, camera 4. Eastfield, 11:14 p.m. 2 figures with a measuring tape inside my property line. The room went completely silent. I played 30 seconds. Then I played the third trespass, the one with 3 figures. The Greenfield land assessor crouching at my vegetable beds, collecting soil samples from land that was not for sale and had never been offered to anyone. I closed the laptop. I told them the land assessor had been identified, that he had been contracted by Greenfield Properties, and that he had conducted an unauthorized survey on private farmland without the owner's knowledge or consent. I told them that was not an HOA administrative function. I told them there was no provision in our charter, the county registered version, that authorized board members to enter private property at night without notice or consent, and that I would welcome Linda's citation of that provision if it existed. I looked at Linda directly. She looked back at me with her expression intact, composed, patient, faintly concerned. But something behind it had shifted. The calculation was running harder than usual. Linda responded immediately when I sat down. She said the footage was being taken out of context. She said board members had conducted a routine community assessment of properties under active violation review, which was within the scope of standard HOA administrative practice. She said the individual I had identified as a land assessor was a consultant retained to evaluate community infrastructure needs, and that his presence on the property was a regrettable procedural misstep that the board took full responsibility for. Regrettable procedural misstep, I said from my seat, without standing. Can you cite the charter provision that authorizes nighttime entry onto private property without the owner's notice or consent? She said the board operated according to its current governing documentation, and that all relevant procedures had been followed appropriately. I said, the charter filed with the county does not contain that provision. I have it here if you would like to identify the relevant section. She did not take the document. Then the room began to move. A man named David Reyes, one of the 5 residents whose signatures had been obtained under false pretenses, stood up from the middle of the room. He said his name had appeared on Linda's Community Concerns report. He said he had not knowingly signed a document recommending the revocation of a neighbor's agricultural exemption. He said he had signed what Linda described as a general quality of life feedback form. He formally and publicly withdrew his name from the document. A woman named Patricia Chen stood up immediately after and said the same thing. Then a 3rd resident, Bill Travers, the older man who had told me on the phone to tell him where to go, and he would say what he knew. He stood up and said it clearly and without apparent nervousness, in the voice of a man who had decided something and was no longer conflicted about it. 3 public withdrawals. In front of 41 neighbors. Gary Purcell, seated at the board table to Linda's left, looked down at the surface in front of him. He did not look up for the remainder of the meeting. He did not speak. He did not defend her. The meeting ended without resolution 40 minutes later. Linda closed proceedings professionally, thanked everyone for attending, expressed her continued commitment to the community. Her voice held. Her composure held. But the room had changed in a way that composure could not address. As the room emptied, I was gathering my folder when the woman with the notebook approached me. She had been sitting near the front the entire meeting, writing steadily. She held out a card. County Sheriff's Office. Investigator. She said she had been watching the meeting on a tip from Rachel's office. She said the trespass footage I had presented, combined with the developer connection I had outlined, had given her office sufficient grounds to open a formal criminal investigation. She said, "We need to talk." I looked at the card for a long moment. Then I looked at her. I said, "Yes, we do." The court dates were set for the same week in March. Civil proceedings on Tuesday. Criminal trespass hearing on Thursday. Rachel had coordinated with the sheriff's investigator, a measured, precise woman named Detective Anita Vowell, to ensure the 2 cases complemented rather than complicated each other. The civil case would establish the property rights framework. The criminal case would address the trespass conduct directly. Both were built on the same foundation of documented evidence. Both were ready. I put on my grandfather's work shirt the morning of the civil hearing. It was the one he had worn in a photograph I kept on the farmhouse wall, faded green canvas, the kind of shirt built for decades of use rather than appearance. It was too wide in the shoulders for me, and I had never worn it before. I wore it that Tuesday and did not think too carefully about why. The Franklin County Civil Courtroom was smaller than I had imagined during all the months I had been building toward this moment. Wood paneling, fluorescent lighting, the low institutional hum of a building that processed other people's problems every working day without particular emotional investment in the outcomes. I sat at the plaintiff's table with Rachel beside me and looked straight ahead. Linda and her attorney, a Richmond firm she had retained 6 weeks prior, a man named Garrett who carried himself with the careful defensiveness of someone who had reviewed the evidence and was managing his expectations, sat at the defendant's table. Linda was dressed impeccably. Dark blazer, hair precisely set, hands folded on the table in front of her. She looked composed and prepared and exactly like herself. I had spent months watching her perform that composure. I was no longer impressed by it. I knew what was underneath it now. I had read her emails. The judge was the Honorable Robert Finley, 64 years old, 30 years on the bench, a reputation for patience with facts and very limited patience with procedural maneuvering. He reviewed the case file for 5 minutes after taking his seat. Then he looked up and the proceeding began. Rachel presented the civil case in 4 organized phases. The first established my property record. 3 generations of continuous ownership. 62 years of active agricultural operation. Every HOA assessment paid on time. Every property tax current. The agricultural exemption clearly documented in the original county charter filing predating the HOA by 26 years. The foundation was clean, and Rachel moved through it efficiently. The second phase was the fraudulent conduct documentation. She presented the email chain first, printed, dated, entered into evidence. She walked Judge Finley through the sequence. Linda's first contact with Greenfield Properties 22 months ago, her description of my exemption as the primary obstacle, her reference to community friction that did not yet exist. She presented the subsequent emails showing Linda's updates to Greenfield on the progress of her violation notice campaign, her community complaint document, her petition preparation. She presented the share purchase records showing Linda's financial position in Greenfield Properties. Garrett cross-examined on the emails. He argued they represented professional networking rather than coordinated fraud. He argued that a real estate professional maintaining contact with development companies was standard industry practice. Rachel asked him to identify the industry standard that involved an HOA president describing a specific resident's property as acquirable and their legal exemption as an obstacle to be removed through county petition, in correspondence with a company she had a financial stake in, before filing a single violation notice against that resident. Garrett said he was speaking to general professional conduct standards. Judge Finley made a note. The third phase was the trespass evidence. Detective Vowell took the stand first. She had spent 6 weeks building the criminal case, and she presented her findings with the systematic precision of someone who understood that courts reward documentation over drama. She confirmed the identity of all individuals captured in the trespass recordings. She confirmed the identity of the third figure from the third trespass, a licensed land assessor named Paul Greer, contracted by Greenfield Properties, whose own records confirmed he had been engaged to conduct a preliminary development feasibility assessment on my property. She confirmed that no entry notice had been provided to me prior to any of the 6 recorded trespass events. She confirmed that the HOA charter contained no provision authorizing board member entry onto private residential or agricultural property without owner consent. 6 trespass recordings were entered into evidence and played in open court. I watched Judge Finley watch them. He watched all 6 without expression, making occasional notes. When the 6th recording finished, he sat back slightly in his chair and looked at the defendant's table for a moment before returning his attention to the proceeding. Garrett's cross-examination of Detective Vowell lasted 9 minutes. He suggested the board members had been conducting administrative assessments in good faith. Detective Vowell said good faith did not authorize entry onto private property without consent under Virginia law, and that the criminal hearing on Thursday would address that matter directly. Garrett concluded his cross-examination. Paul Greer, the land assessor, testified under subpoena. He was visibly uncomfortable. He was a working professional who had accepted a standard contract from a development company and had not anticipated sitting in a civil courtroom as a consequence. But he was honest in the way that uncomfortable people are sometimes more honest than comfortable ones, because the cost of maintaining a false position felt higher than the cost of telling the truth. He confirmed the contract with Greenfield. He confirmed the date of his site visit. He confirmed that he had been told by his Greenfield contact that the property was in the process of being acquired and that preliminary soil and site assessment was required for development planning. He confirmed he had not contacted me directly because his Greenfield contact had told him the acquisition was proceeding through HOA channels, and that owner contact was not required at this stage. He said that last sentence, and then appeared to realize how it sounded in a courtroom. Garrett declined to cross-examine Paul Greer. 5 residents who had been misled into signing Linda's complaint document testified in sequence. They each described the same experience in their own words. Linda presenting a document as a general community feedback form. The absence of any explanation that it would be used as a formal complaint recommendation targeting my specific property. Their surprise at seeing their names on the printed report distributed at the HOA meeting. Bill Travers was last. He was 71 years old and had the particular directness of someone who had decided he was done being careful. He said, "I signed because Linda told me it was a general petition. If she had told me it was a recommendation to strip a neighbor's family farm of its legal protection so a developer could buy it, I would have told her to take her petition and her clipboard and leave my porch." The room was very quiet after that. The 4th phase was the land use notation. Rachel placed the county filing before the court. She explained its legal mechanism, the procedural claim designed to establish HOA interest in my property, time to mature in combination with a successful exemption revocation. She showed the filing date, 14 months ago. She showed that I had not been notified of the filing. She showed that no community vote had authorized it. She showed that it had been filed by Linda Marsh in her capacity as HOA president, while she held a financial stake in a development company that had expressed acquisition interest in the same property. Judge Finley asked Garrett one question during Rachel's presentation of the notation. He asked whether the defendant could identify the HOA board resolution authorizing the filing of a land use interest claim on a resident's private property. Garrett said he would need to review the board records. Judge Finley said he would have that answer before the proceeding concluded. The answer, when Garrett provided it after a 30-minute recess, was that no such board resolution existed. Linda had filed the notation unilaterally, without board authorization, without community vote, and without notifying me. Linda took the stand in the afternoon session. She had insisted on testifying. I learned this from Rachel during the recess. Garrett had advised against it and Linda had overruled him. She believed she could manage her testimony the way she had managed everything else, through composed, confident, carefully controlled performance. She was composed for the first 20 minutes. She described her years of service to the community with genuine feeling. She described the violation notices as good faith responses to resident concerns. She described the developer contact as professional networking. She described the trespass recordings as administrative assessments conducted in the community's interest. Then Rachel stood up. She asked Linda to explain the specific language in her first email to Greenfield, the description of my exemption as the primary obstacle to acquisition in the context of her claim that she had been acting in the community's interest rather than in her own financial interest. Linda said the language had been taken out of context. Rachel placed the full email in front of her and asked her to identify the context that altered its meaning. Linda reviewed the email. Then she said the correspondence reflected preliminary exploratory discussions that had not resulted in any formal action. Rachel asked her whether filing a land use notation on a resident's property title without board authorization or owner notification constituted formal action. Linda said the notation was a standard procedural measure within HOA administrative practice. Rachel asked her to cite the charter provision authorizing that measure. Linda said the board operated according to its governing documentation. Rachel asked her which version of that documentation she was referring to, since the county-registered charter contained no provision authorizing unilateral property title filings by the HOA president. Linda said she would need to review the specific language. Rachel said she had the document available and asked Linda to identify the relevant section. Linda reviewed the document for a long time. The courtroom waited. She could not identify the section because it did not exist. Judge Finley called a 30-minute recess. I stood in the courthouse corridor during recess with a paper cup of water and looked out the window at the March sky. Rachel came to stand beside me after a few minutes. She said nothing for a while. Then she said the recess had been called because Judge Finley wanted to review two specific documents before delivering his findings and that she was comfortable with where things stood. I told her I was too. I thought about my grandfather. About the spring of 1961, when he had stood at the edge of an empty field in Virginia with a survey map in his hands and stone markers in his truck and 60 years of farming ahead of him. He had not built that farm because he expected it to be easy. He had built it because it was worth building. I thought it was still worth it. Judge Finley delivered his findings with the efficiency of a man who had made up his mind before the recess and was now simply making the record. The land use notation was fraudulent, unauthorized, and void. It was ordered expunged from my property title immediately. The HOA's violation notice campaign had been conducted in bad faith by a board president with an undisclosed financial conflict of interest, rendering all associated notices legally unenforceable. My agricultural exemption was confirmed as legally valid and protected. The HOA was ordered to cease all action against my property and to bear my full legal costs. I was awarded compensatory damages of $18,000. The financial irregularities surrounding Linda's conduct were referred to the county attorney's office for further review. Judge Finley removed his reading glasses and looked at the defendant's table. He said, "This court has reviewed the conduct described in this proceeding with considerable attention. What the evidence establishes is not administrative overreach or procedural error. It is a deliberate effort by an HOA officer to weaponize community governance mechanisms for personal financial gain at the direct expense of a property owner whose family has worked this land for 60 years. This court will not dignify that conduct with measured language. It was wrong. It was documented. And it is finished." He closed his folder. The criminal hearing was Thursday. I drove home through my own land that evening, turned off the main road onto the farm access track, the way my grandfather had turned off it 10,000 times before me, and drove slowly along the edge of the east field with the window down and the March air coming in cold and clean. I stopped the truck at the stone corner marker my grandfather had set in 1962. Got out. Stood in the field. Put my hand in the soil the way I had done since I was old enough to reach it. The corners were set. They had always been set. I stood there until the light was gone. Then I drove up to the farmhouse, went inside, and made dinner in the kitchen my grandfather had built. Thursday was coming. We were not finished yet. But the ground beneath me was solid. It had always been solid. I had just needed to prove it. The criminal hearing on Thursday lasted 4 hours. Detective Vowell presented the trespass evidence with the same systematic precision she had brought to the civil proceeding. 6 recordings, 6 dates, 6 entries onto my property without consent or notice. Linda and Gary Purcell were represented by separate attorneys now. Garrett had withdrawn from Linda's representation the morning after the civil verdict, citing scheduling conflicts that nobody believed. Paul Greer, the Greenfield land assessor, had already entered a plea agreement with the county attorney's office in exchange for his full cooperation. The criminal court judge reviewed all 6 recordings. He reviewed Detective Vowell's documentation of each trespass. He reviewed Paul Greer's cooperation statement confirming Greenfield's involvement and Linda's role in coordinating the unauthorized site assessment. He reviewed the chain of communication between Linda and the Greenfield acquisitions director, establishing that the trespass activity was not incidental HOA administration but a coordinated effort in service of a private development interest. Linda's new attorney argued good faith. The judge asked the same question Judge Finley had asked in the civil proceeding, the charter provision authorizing nighttime entry onto private property without owner consent. There was still no answer. There had never been an answer. There never would be one because the provision did not exist and had never existed, and Linda had known that when she crossed my grandfather's stone markers in the dark. The verdict came in the late afternoon. Linda Marsh and Gary Purcell were found guilty of criminal trespass. Both were fined. Both received probationary sentences. Both were permanently barred from serving on any homeowners association board in the state of Virginia for a period of 10 years. Paul Greer received a reduced fine under the terms of his cooperation agreement. I sat in that courtroom and felt something settle in me that had been unsettled for a long time. Linda vacated the HOA presidency the following morning. No letter. No statement. No farewell to the community she had managed for 5 years. Her pearl-white SUV was gone from her driveway by the weekend. Whether she had left the development entirely or was simply keeping a low profile, I did not know and did not ask. I had spent enough time thinking about Linda Marsh. I was finished with that. The interim board convened within 10 days. 3 residents who had stepped forward voluntarily, none of them connected to Linda's circle. Their first official act was drafting a formal written apology to me, which they delivered in person at a brief community meeting. The board chair, a quiet retired engineer named Thomas Park, read it aloud in front of 30 residents. It was straightforward and without qualification. It acknowledged what had happened. It acknowledged that the community's governance had been used against one of its own members in a way that was wrong. It expressed genuine regret. I thanked them and meant it. On a Saturday 2 weeks after the verdict, I came out of the farmhouse at 7 in the morning to find 5 neighbors standing at the edge of my property with tools. David Reyes, Patricia Chen, Bill Travers, Carol Briggs, and Gerald Henderson from 3 houses down, who had told me months ago about Linda describing my land as underutilized, and who had clearly been carrying that quietly ever since. They had come to fix my east fence line. During the 3rd trespass, the night Paul Greer had collected soil samples, one section of the fence had been damaged. A post knocked loose, 2 rails displaced. I had documented it, photographed it, included it in the legal filing. But I had not repaired it yet. I had been too focused on everything else. I stood on the porch and looked at them for a moment. Bill Travers said, "We figured we owed you a fence." We worked through the morning. Nobody made speeches. Nobody offered extended apologies or lengthy explanations. We just worked. Setting the post, rehanging the rails, checking the alignment against the original line. The kind of work that moves forward steadily when everyone does their part without needing to be directed. My grandfather would have recognized it. He had built this farm on exactly that principle. By noon, the fence was solid. Carol Briggs had brought food. We ate on the porch and talked about ordinary things, the season, the garden, the chickens, the 2 goats who had stationed themselves at the fence line to observe the proceedings with their characteristic lack of interest in human concerns. It was the first ordinary morning I had spent on this farm in a long time. Greenfield Properties withdrew their interest in my land within 3 weeks of the civil verdict. No letter. No formal communication. Rachel simply received a brief notice from their legal department stating that Greenfield was no longer pursuing acquisition opportunities in Pinecrest Valley. Rachel forwarded it to me with a single line. They are gone. I printed it out and put it in my grandfather's filing cabinet, in the same drawer as his original land survey, and the property deed and the HOA charter, and every violation notice Linda had ever sent me. A complete record. From the beginning to the end. I planted a new row of sunflowers along the south fence line on a Tuesday afternoon in April. Same variety Linda had cited in her third violation notice, the one about height and visibility obstruction. I planted them in the same location, the same spacing, the same depth. I had saved seeds from last year's crop, the way my grandfather had taught me, and I put them in the ground by hand, one at a time, working down the fence line in the afternoon light. There was something deliberate about it that I did not feel the need to explain to anyone. The county attorney's office opened a formal investigation into Linda's financial conduct, the Greenfield share position, the undisclosed conflict of interest, the unauthorized land use notation within 30 days of the civil verdict. Rachel told me the investigation was likely to take 6 to 12 months, and that its outcome was not guaranteed. I told her I understood. I had done what I could do. The rest was other people's work now. Rachel also told me that the civil verdict had been noted by 2 property law organizations in Virginia as a significant precedent for HOA overreach cases involving undisclosed financial conflicts of interest. My case would be cited. My grandfather's farm would appear in legal footnotes. He would have found that quietly satisfying, I thought. He had a particular appreciation for things that lasted. On an evening in late April, I sat on the porch as the light went out of the sky. The east field was quiet. The cameras were still running, all 8 of them, all angles covered. Not because I was afraid, not because I expected trouble, but because this land was worth watching over, and I had learned it the hard way and I was not going to unlearn it. The sunflowers along the south fence were 2 inches out of the ground. In the farmhouse hallway, my grandfather's land survey hung in a frame beside the photograph Patty. I thought of her now, the neighbor who had helped me through all of this, though her name belonged to a different story. Beside the photograph a neighbor had taken of the farm years ago, the survey with his handwritten margin notes. The corners set in stone. Permanent. I sat on the porch my grandfather had built and listened to the farm settle into evening around me. The land did not lie. Neither did the cameras. And neither, in the end, had the truth. There is something they do not tell you about inherited land. They tell you about the taxes, the maintenance, the responsibility of keeping something old alive in a world that moves fast. What they do not tell you is what it costs when someone decides that your history is an obstacle standing between them and a business opportunity. What it feels like to watch footage of someone walking across your grandfather's field at midnight with a measuring tape, treating 60 years of your family's work like a line item in an acquisitions portfolio. I did not ask for any of this. I paid my dues. I maintained my property. I minded my land the way my grandfather taught me. And someone looked at that quiet, working farm and saw a transaction waiting to happen. They were wrong. But here's what I know now that I did not know before all of this started. Knowing your rights is not enough if you do not document them. A property deed in a filing cabinet protects nothing if you do not know what is being filed against you at the county level. An agricultural exemption that predates your HOA by 26 years means nothing if someone quietly challenges it while you are not watching. So watch. Install the cameras. Read the county filings on your own property. Attend the meetings. Know which version of your HOA charter is the legally registered one. Check whether your board members have financial relationships with companies that might benefit from decisions they are making about your land. My grandfather always said, "Land does not lie. Neither do cameras." If any part of my story felt familiar, if someone has treated your property like an opportunity they had not been given yet, tell me in the comments. I read everyone. Subscribe. New story every week. Next week, a veteran comes home to find his HOA has been finding his empty house for 2 years. The money went somewhere. Nobody can explain where. You will not want to miss it.